On our last episode of Heirlooms and Legacy,
my family law case is the new prey waiting to be picked apart and pillaged.
I guess I'll never get my fresh start from everything being made so impossible.
It simply seems I cannot forgive and be forgiven and move forward.
Sarah's quest for $62,000, legacy, heirlooms, and second chances just hasn't been going right. Tell me and we'll both know. Heartache and pain, heartache and pain. So, as we count down to the Boone versus Boone family law case coming up August 25th, 2025, some of you in the comments section have mentioned that Brian actually did file to stop his alimony and child support payments. So today, we're going to look over the documents. Get ready. And let's get this party started. Okay, on the screen you should see the supplemental petition for modification of final judgment. And it reads, the former husband, Brian C. Boone, individually and by and through his undersigned attorney, hereby files this petition for modification of final judgment of dissolution of marriage, dated June 15th, 2018. And states as follows. 1. Action for modification. This is an action for modification of the final judgment entered by this court on June 15, 2018. The final judgment incorporated the marital settlement agreement and parenting plan, both executed on May 3, 2018. A copy of the final judgment is attached hereto as Exhibit A. And we have already looked over the dissolution of marriage. 2. Jurisdiction and venue. Pursuant to paragraph 10 of the final judgment, this court retained jurisdiction over the parties, the minor child, and the subject matter of the proceedings. Venue is proper in Orange County, Florida, as both parties and the minor child reside in Orange County. Sidebar. This divorce was final in 2018, and Sarah was the suitcase killer by 2020. She only survived for 2 years on her own in the world, and not really on her own because Brian was pretty much supporting her. Okay, so this is where it gets good. 3. Substantial change in circumstances. Since the entry of the final judgment, there have been material and substantial changes in the circumstances that require a modification to the parenting plan, marital settlement agreement, and final judgment, including but not limited to the following. A. On February 25th, 2020, the former wife was arrested and charged with second-degree murder of her boyfriend after she locked him in a suitcase. The former wife was committed to the custody of the sheriff of Orange County and has been held without bail, ceaselessly and endlessly nonetheless. The parties have one minor child, LMB, born 2010. The minor child has lived exclusively with the former husband since the former wife's incarceration and lived the vast majority of the time with the former husband since the parties' separation on September 11th, 2017. And rest in peace to all the 9/11 victims. C. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. The former husband has voluntarily deposited money into the former wife's inmate account so that she may be able to purchase items from the inmate commissary. How nice of him. And we know that Brian has sent Sarah money, but it's never enough for her. She constantly wants wings, 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 and burgers. 4. Modification of shared parenting. Due to the former wife's lack of proper judgment and as described above, and because of her behaviors in front of the minor child prior to her incarceration, it is in the minor child's best interest for the former husband to be awarded sole parental responsibility, decision-making, and 100% time sharing. The former wife does not have the mental or physical ability to co-parent at this time, nor can she exercise any time sharing. Okay, Brian, let's go. Maybe that's why Sarah was coming down so hard in her response. 5. Termination of alimony. Paragraph 4 of the final judgment requires the former husband to pay durational alimony to the former wife in the sum of $1,000 per month for a period of 84 months. The former wife does not have the financial need for alimony at this time and will not throughout the period of the durational alimony, which, if not earlier terminated or modified, would end with the payment due on April 1st, 2025. Also, due to the former wife's admitted egregious behavior of locking her live-in boyfriend in a suitcase, which ultimately led to his death, she is not entitled to alimony. The termination of the durational alimony should be retroactive to February 25th, 2020, the day of the former wife's arrest and incarceration.
I'm just tired of it happening. I mean, it was...
In the alternative, the former husband requests that the alimony be reduced or at least suspended for the period of time that the former wife is incarcerated for putting her live-in boyfriend in a suitcase and leaving him there, possibly tossing him down the stairs. So this is everything we've been discussing down in the comments about how Sarah is a ward of the state and all of her needs are met. However, Brian didn't even mention the fact that Sarah has fans all around the world depositing money into her account, supporting her, providing her wardrobe, offering her documentaries, 9 representatives. She has people buying her wings and burgers and honey buns. Sarah has people buying her cheese. She has people depositing credits onto her account constantly, in addition to former husband's help. Termination of child support. Paragraph 6 of the final judgment requires the former husband to pay the former wife the sum of $100 per month towards the support of the minor child, based on the equal time sharing schedule outlined in the parenting plan on the financial abilities of the parties at that time. Since February 25th, 2020, the minor child has lived exclusively with the former husband, who is responsible for 100% of his financial needs. The former wife does not incur any expenses for the minor child and as such is not entitled to child support. The termination of child support should be retroactive to February 25th, 2020. The day she put her boyfriend in a suitcase, possibly tossing him down the stairs and ending his life. 7. Attorney's fees and cost. All right. Attorney's fees and cost. The former husband attempted to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental petition for modification and requested that the undersigned attorney prepare a joint stipulation. The former wife would not sign the joint stipulation, which resulted in the filing of this action. The former wife should bear the responsibility of the former husband's attorney's fees, as her actions and her failure to act as necessitated the attorney's fees. Wherefore, the former husband urges this court to modify the final judgment and grant the following relief. A. Okay, listen close. Award the sole care and custody of the minor child to the former husband, as well as 100% time sharing and decision making. Sidebar. You would think that is automatic once a parent is convicted of a life sentence. Not just convicted, because even parents that are incarcerated have rights. But if you have a life sentence without parole, I think it should be automatic that if there's another living parent, excuse me, or guardian, that they should be granted 100% time sharing and decision making. What do you guys think? B. Terminate the former husband's alimony obligation to the former wife, retroactive to February 25th, 2020. Or, in the alternative, suspend all payments during the former wife's incarceration. Terminate the former husband's child support obligation, retroactive to February 25th, 2020. Order the former wife to pay the former husband's reasonable attorney's fees and cost necessitated by her actions, and order such other relief as this court deems proper. Dated this 18th day of February 2022. Signed by Brian Boone, and it was submitted to the state of Florida, county of Orange. So, now, my mathematicians down in the comment section. Brian Boone attested Sarah's alimony payments back in 2022 of February. That was 2 years into her prison sentence. So, would Brian be on the hook for the 2 years prior to, or would he be on the hook for everything? Of course, Sarah wants him to be on the hook for the past 5 years. However, I believe the judge... Hold on, I'll be right back. Let me go and double check.
And you would not answer Brian Boone, your ex-husband's phone calls, just so that you could let him know that you're busy and you have things going on, correct?
Should I not be incarcerated, which makes no difference and is temporary, former husband would have his license suspended, wages garnished, or be arrested and put in jail, where he'd get the idea real quick how it really works, quote unquote, and understand everything I've been trying to explain to everyone for years now. Groceries, bill payments, cell phone, and miscellaneous entertainment. Okay, I found the judge's response to Brian's amendment modification. Now, we've already went over, if you've been keeping up with our family law playlist, the contempt that Sarah was trying to get Brian held in. We went over her order for contempt. Now, this is Brian's response. So, now here's the judge's response to everything. And this is from Judge Michael Dean, and it's the order of the outcome of the conference management meeting, October 16th, 2023, and the court, having heard from all parties present, finds and orders as 1. Both parties appeared for the case management conference, which included a motion to withdraw by the respondent's former wife's counsel, Frank Bankowitz, because a court date isn't a court date if Sarah isn't losing an attorney, right? There were no objections to the withdrawal of the respondent's counsel. Frank Bankowitz is hereby removed as counsel for the respondent, Sarah Boone. Counsel shall provide a more formal proposed order for this removal to be signed by the court within 10 days. Frank just wrote a note on a piece of paper and said, "Judge, I'm out of here." And the judge said, "Okay, send it to me in a proper order in a few days, Frank. You're free." 5. The case management conference discussed the status of the case, including the petitioner's, Brian Boone's, request for a reduction or elimination of alimony and for relocation. And sidebar, we know that Brian was able to move. Him and little man were able to relocate and start fresh. 6. The respondent, Sarah Boone, is currently incarcerated in the Orange County Jail, pending trial on a charge of second-degree murder for putting her live-in boyfriend in a suitcase and possibly throwing him down the stairs and ending his life. 7. The court cannot hear the respondent's, Sarah Boone's, motion for contempt regarding unpaid alimony until after a final hearing is held on the respondent's, Sarah Boone's, petition for reduction or elimination of alimony. And it lists the case law, which reversed a trial court's contempt order because it was issued before the modification action was heard. So even if he was held in contempt, it was reversed after the modification was heard. The respondent 8. The respondent expressed frustration at not having matters heard and not being adequately informed about her case. Of course, because Sarah likes to be highly involved in her case. Invest in the oppressed. Okay, make sure you're listening because this is where it gets good. 9. The court explained that the family case is on hold pending the outcome of the respondent's, Sarah Boone's, criminal case. 10. The court finds that I lost my place. The court finds that the permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's, Sarah Boone's, case so that the circumstances are more clearer, so that I know what to plan on. 11. The respondent was informed that she may opt for a final hearing on the petitioner's, Brian Boone's, petition for alimony reduction, elimination, and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. 12. The respondent, Sarah Boone, was advised to ensure that any motions filed conform to the Florida Family Rules of Procedure and the Florida Rules of General Practice and Judicial Administration. This includes utilizing proper captions, titles, and certificates of service. Ordered in Orlando, Orange County, Florida, on this 16th day of October 2023 by Judge Michael Dean. So Judge Dean said, Sarah, you can't just scribble on a piece of paper. You're going to have to make it proper. And boy, did she make it proper in her 33-page response that we went over already, where she made all these crazy demands. And what do you guys think as far as the dates? Brian filed for a motion to reduce the alimony or eliminate it in 2022. However, Sarah is ignoring that and just saying that he stopped on his own. Now, did Brian stop on his own? I don't think so. It looks like maybe he should be prepared to either pay the $62,000 or the payment from her date of incarceration to the date he filed. I don't know. What do you, my lawyer people down in the comments, let me know. Meanwhile, Sarah is ceaselessly and endlessly in a pursuit for her heirlooms, legacy, and $62,000. The excellent mother to her son didn't mention anywhere in these documents, I need you. Can you please make me proud? Take care of little man. And that $1,000, you keep that for you and little man. And how about maybe you can give me the $100? Give me the $100 monthly, and I'll survive off of that and make it work. And even though Brian doesn't owe her anything, and any money she receives should actually go to the Torres family, I think Brian is a nice guy and probably would have went for it. This one is a doozy because Sarah is adamant that she's owed $62,000. However, Brian did file to stop, but the judge just left it until her case was sentenced. So now that she has been sentenced, they're revisiting the case, and it's going to be up to the judge to determine. But the judge clearly said in, I think, number 11, that he would have to take into consideration her current incarceration status. Is she not taking a hint that, hey, you're incarcerated, you have no need for alimony or child support, and she has no need to dictate how the child support is spent. That's pretty obnoxious in my opinion. She wants to sit back in her cell, eat wings and burgers that Brian pays for, and tell him how to spend his hard-working money. Oh, Sarah. Negative officer contact. Inmate Boone is receiving this negative for her attitude. Inmate Boone was assigned to clean the inmate restroom. While speaking with another inmate, Inmate Boone rudely interrupted, stating that she needed a garbage bag. She was informed that if she couldn't clearly see I was speaking with someone, that her interrupting was rude and she needed to wait. She immediately got an attitude stating, quote, "All I asked for was a garbage bag. I'm the one cleaning and I'm just trying to get it done." She again was addressed on her attitude, to which she apologized. Classification note. Inmate Boone, Sarah, was removed from the faith-based program on Tuesday due to several complaints of intimidation, bullying, and antagonizing inmate workers in the dorm, specifically dorm workers. I spoke with her approximately 3 weeks ago due to complaints from an inmate worker assigned to the dorm trustee. I advised her she would be removed from the faith-based program and relocated if she continued this negative behavior. Her negative behavior has continued, and therefore she was relocated to a new housing dorm to resolve this issue. On today, November 9th, Inmate Boone approached the officer desk and asked if any mail came today, and I told her no. Inmate Boone didn't like that answer, so she got an attitude and continued questioning this officer about the mail. She stated that she finds it very odd that the mail hasn't come today in 3 days and demanded that I call and check to see if B dorm has any incoming mail for today. I then explained to Inmate Boone that I am unaware about the past few days because I wasn't the dorm officer. I can only speak for today that there is no mail for B dorm today, and lastly, I don't need to call anyone regarding mail. FDC has a system put in place for mail. Inmate Boone then demanded an inmate request form. The form was made available to her, and she stormed off. Inmate Boone constantly questions the officer's authority and gets an attitude when she doesn't get her way. Negative earned. Negative officer contact. And this is shortly after the last officer contact, so Sarah's on a roll today. All inmates were given dorm expectations several times. There is no talking in the bunk, shower, or bathroom areas. After ensuring all inmates understood the verbal orders given to them, while conducting chores of the dorm, the inmates continued to talk in the bunk area. All the inmates in the dorm were informed that they would remain on their bunks for 2 hours, which was documented in my IMS. Inmate Boone, however, approached the officer's desk stating that she had to contact her attorney before 2 p.m. I advised Inmate Boone that once the 2 hours are over, the phones will be available for use. Inmate Boone then started to become argumentative with me, stating that this is not fair and this is cruel punishment. Inmate Boone requested an inmate request form to speak with a supervisor. Inmate Boone turned in an inmate request form on this matter, which was given to the supervisor.
I knew George better than I did. I say that I knew George better than himself. And I tried in every way, shape, and form. Ask everyone. I helped him. I took care of him. I miss him a lot, and I didn't even sleep last night. I miss him a lot.
I mean, is there any chance it got to be too much for you and you couldn't handle taking care of him and
I never stopped.
trying to...
I never
help
stopped.
him?
That's what I'm here for. I never stopped. I'm here now because I'm still trying to help him.
Yeah.